Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to describe how a probate works from start to finish. Now, the rules of each state can vary somewhat, and in this video I'm going to describe exactly how a Louisiana probate gets handled. It's worth noting at this point that while other states call this proceeding probate, Louisiana refers to the succession as the court and attorney involved procedure that's required when someone dies with assets in their name, such as real estate, a business or LLC, bank accounts, or stock brokerage accounts. And there's no way to transfer those assets to the heirs other than to get the judicial system involved and get judges to sign court orders ordering that assets be transferred to the appropriate heirs. And since every probate is different, let's apply the rules to a specific example. Let's say mom dies, leaving a will that says her 3 children are to divide mom's estate equally. Let's also assume that mom designated her oldest child, Peter, as the executor. And mom dies owning a home, bank accounts, brokerage accounts, and ownership or membership interest in a limited liability company or LLC, a traditional IRA, and a vehicle. The total value of all of mom's assets at the time of her death were $2 million. Mom also had a couple of outstanding credit card bills and medical bills that need to be paid. That debt totaled $25,000. So the first thing that we do is we get mom's son, Peter, confirmed as the executor. And just because mom named Peter as executor in her will doesn't automatically make him the executor the moment that mom dies. Court pleadings must be prepared, signed, and filed at the courthouse, where the executor is formally asking a judge to declare that mom's will is valid because it meets all of the validity requirements, and it's requested that a judge sign the appropriate court orders declaring or confirming that Peter is now officially the executor. It's worth noting here that in Louisiana, it's not necessary that the family wait to receive the death certificates prior to starting or completing these steps to get Peter confirmed as the executor. Instead of filing death certificates at the courthouse with the pleadings, 2 people, probably Peter and someone else, will sign affidavits attesting to the circumstances surrounding mom's death. Once the judge signs the initial court orders, the clerk of court will issue several certified copies of what some states call letters testamentary, but in our case, we'll call it in Louisiana, letters of independent executorship, or for short, letters. And by now, perhaps the death certificates have arrived, so Peter takes mom's death certificate and the letters to the bank and brokerage firm. After the bank lawyers and the brokerage firm lawyers review these letters, they will authorize the opening of an estate account at the bank and at the brokerage firm. Mom's bank funds will be moved into the estate account at the bank. Mom's investments in her brokerage account will be moved into the estate brokerage account. These financial institutions will require that the executor supply the estate's tax identification number to them before they open the estate account. So perhaps Peter's attorney applied online with the IRS and received the tax identification number so that Peter could open the estate accounts. Typically, the next thing that Peter would do is pay mom's unpaid credit card and medical bills out of the estate account. Peter will also work with the attorney that Peter and the heirs hired in order to prepare the estate's required detailed descriptive list of assets and liabilities, sometimes informally referred to as an inventory. This lists all of the probate assets and all of the debts of mom as of the date that mom died. It's worth noting at this point that one of mom's assets was a traditional IRA, not a Roth IRA. Assuming mom named her 3 children as equal primary beneficiaries on the financial institution's beneficiary designation form, the kids will work directly with the financial institution where the IRA is held, and the financial institution will set up 3 inherited IRA accounts, one for each of the 3 children. Because the IRA has designated beneficiaries, it is not considered a probate asset and does not get listed on the probate list of assets. The 3 children do not need to go through lawyers, courts, and judges to gain access to mom's IRA assets. They just need a death certificate. Now, for one reason or another, let's assume there's been some delay and it's now several months after mom died. While unreasonable delay does not occur in every probate, some of the reasons for probates taking a long time include the family waiting longer than necessary to hire the lawyers and start the proceedings, the attorney taking too long to prepare or file the appropriate court pleadings, one or more of the heirs delaying in doing their part to participate in and sign court pleadings, the judge's office taking a long time to review and sign the appropriate court pleadings and court orders, the courthouse employees taking a long time to process the court paperwork, or the financial institution employees and attorneys taking a long time to approve the opening of the estate account and the movement of funds or investments into the new estate account. So now it's several months after mom died, or if glitches occurred, it could be years, and the estate's debts and bills have all been paid from an estate account by the executor. Perhaps the executor sold mom's vehicle and the proceeds of that sale are in the estate account. And maybe the executor sold mom's house and the proceeds of that sale, which were payable to mom's estate, were deposited into an estate account. So now another round of court pleadings is prepared by the attorney for the executor and heirs. These court pleadings request that a judge sign what's known as a judgment of possession. All of the heirs must sign a document verifying that all of these court pleadings are accurate, and these final pleadings get filed at the courthouse. Perhaps a few days, weeks, or months later, a judge will sign this final court order ordering that the estate assets be transferred, pursuant to the terms of the will, to the 3 children equally, and that any remaining assets that were not disposed of while this estate was under administration, such as mom's interest in her LLC, be transferred to the 3 children. After that judgment of possession is signed, the executor will disperse estate funds from the estate account to the 3 heirs, and a certified copy of this judgment of possession will be submitted to whoever handles the records of the LLC so that mom's membership interest can be split into 3, so that each child will then own a membership interest equal to 1/3 of what mom's membership interest was. So while some probates go relatively smoothly, some can take a long time or get chaotic. One of the problems with probate is that so many people are involved. The heirs, the lawyers, courthouse employees, judges, employees of banks and brokerage firms, and people who handle real estate titles. In addition, when the heirs and lawyers don't trust each other, or heirs are less than amicable between each other, sometimes heirs get reluctant to cooperate or sign the various levels of court documents, because when heirs are sharing this pot of an inheritance, sometimes you could cut the tension with a knife. Hope that helps. We'll see you next time.